In a bid to completely overhaul the colonial era criminal laws, three bills were introduced in Lok Sabha to replace the Indian Penal Code 1860, the Code of Criminal Procedure 1973, and the Indian Evidence Act 1872. The three bills have been revamped to remove any traces of colonial mindset. अब आईपीसी को रिप्लेस किया गया है बाय द भारतीय न्याय संहिता बीएनएस बिल 2023। सीआरपीसी बन गया है भारतीय नागरिक सुरक्षा संहिता बीएनएसएस बिल 2023 और इंडियन एविडेंस एक्ट को अब भारतीय साक्ष्य अधिनियम या बीएसए से जाना जाएगा। In BNSS, there are 533 sections instead of 478 sections in CrPc. BNS has 356 sections instead of 511 in IPC, and BSA has 170 sections instead of 167 in Indian Evidence Act. इन सब बिलों में बहुत सारे सेक्शंस को अमेंड किया गया है, ऐड भी किया गया है और बहुत सारे सेक्शंस को रिपील भी किया गया है। सो द हाइलाइट्स ऑफ द थ्री बिल्स आर: नंबर 1, ग्रेटर यूज ऑफ टेक्नोलॉजी यानी एविडेंस लॉ में इलेक्ट्रॉनिक एंड डिजिटल रिकॉर्ड, ईमेल, डॉक्यूमेंट्स ऑन कंप्यूटर, मेल मैसेजेस ऑन डिवाइसेस, लोकेशन एविडेंस एटसेट्रा को भी कंसिडर किया जाएगा एज एविडेंस। नंबर 2, mandatory use of forensics and forensic experts in all states and union territories, especially for offences punishable with 7 years or more imprisonment. Number 3, introduction of community service as punishment for certain offences. Number 4, new offences such as terrorism, organized crime, mob lynching, and hate crimes entering into sexual relations with a woman after falsely promising her marriage, job, promotion, etc. have been introduced. Number 5, punishment for offences against women and children such as trafficking, gang rape, etc. have been increased. Number 6, to fast-track dispensation of justice, summary trials have been made mandatory to quickly expedite petty cases, that is less serious cases, such as theft, trespass, breach of peace, etc. Number 7, for the convenience of citizens, zero first information report, electronic FIRs को allow किया गया है. Also, FIRs can be filed in any police station even if the crime doesn't fall under its jurisdiction. Number 8, importantly, sedition को retain नहीं किया गया है. उसके बदले introduction of acts endangering sovereignty, unity and integrity of India as an offence को incorporate किया गया है. Number 9, BNSS के अंडर कहा गया है that even if an accused is not present during the conduct of a trial, the court can proceed to try him 90 days after the date on which the charges are framed. ऐसे और भी बहुत सारे नए provisions को introduce किया गया है while repealing the others. Although the bills have been brought with great intentions, however, certain lacunas have been pointed out, such as number 1, vague definitions like that of sedition can lead to more curtailing of freedom than allowing for it. Broad terms such as in the interest of sovereignty can be easily misused by the government to curb dissent. Number 2, most of the provisions from the old IPC, CrPc and Indian Evidence Act have been retained. Therefore, it cannot be called as a major reform. Number 3, merely focusing on amending provisions isn't enough. बहुत सारे social and institutional reforms भी necessary है जिसके लिए कोई भी provisions नहीं बनाया गया है. For example, increasing number of under trials and overcrowding of prisons has not been addressed in the new bills. Neither has been custodial deaths, encounter killings, police interrogation etiquettes, etc. been resolved. Number 4, the government has also been accused of not holding broader stakeholder and public consultation before drafting these laws. However, conclusion में हम ये कह सकते हैं कि बहुत सारे provisions such as the ones related to technology, forensics, community service, etc. are progressive steps in the right direction. और भी बहुत सारे holistic reforms चाहिए to better our criminal justice system. But these bills can help us achieve that, one step at a time. For more informative videos like this, follow Exact Eyes.